Before we proceed, I have a disclosure to make. I was appointed by the governor and assumed my role in January of 2023. At that time, I was required to file as a candidate to hold my seat after the appointment. I had many state and local judges and elected officials, including, I believe, the mayors of all of the Thurston County cities, endorse me. That includes Debbie Sullivan. And for that reason, I want to make sure that I, one, disclose it, and two, allow you an opportunity to request that I recuse. Does either party wish to make a motion?
Mayor Sullivan does not.
No, Your Honor, thank you.
All right. All right, we will proceed then. Let me explain how we got here procedurally. The motion was made on very short notice as an emergency motion last Friday for a tree removal that the court was informed was going to happen on the next business day in the morning before the court day. For that reason, given the emergency situation and the fact that removal of the tree would end any ability to litigate the case, the TRO was entered. Having seen that, when I was then assigned as the judge, I noted a hearing because a hearing needs to be noted to consider the TRO to ensure that notice is provided and that the parties can be heard. So this was not in response to an ex parte request to shorten time of any sort. It was to make sure that we did get this into court properly. The TRO did not contain an end date, which was another issue that needed to be addressed promptly. That being the case, we are going to hear today the motion to dissolve as well as the motion to extend. So we will cover all of those matters today and make sure everyone is heard.
Your Honor, I do object to the consideration of the motion to extend, and I'll address that at the end of my motion to dissolve.
Mr. Myers, I'm going to hear first the motion to dissolve. I will then rule on that. I will then proceed to hear, if necessary, the motion to extend. At that time, you may make such arguments if that time arises.
Thank you, Your Honor.
You may begin with respect to your motion to dissolve.
Your Honor, with respect to our motion, it is considering the motion to dissolve the ex parte TRO that was issued by this court on a week ago today. We believe that the TRO was issued improperly and that it is deficient in numerous respects with the contents of the TRO that was presented to the court. First of all, it was improper because there was no notice given as required by RCW 7.40.050 and CR 65. Both of those require the party who is seeking a TRO to attempt to notify the others or to demonstrate in their pleadings why notice could not be provided and describe the efforts. The materials that were provided along with the TRO, which were not served on the city until after the TRO had been issued. But the materials that were presented did not describe why a TRO could not be issued without providing prior notice to the city of Tumwater and the city attorney and Mayor Debbie Sullivan. The city maintains offices here. This dispute has been ongoing and discussed in numerous city council meetings for the better part of a month and a half. There is no reason to believe that parties seeking a restraining order could not have notified the city at least a day before a TRO was sought. Instead, what we got was a voicemail at 8:02 a.m. In which Ms. Larson Kramer stated that she wanted to contact the city attorney so that she could, quote, inform her that I'm filing a motion for a temporary restraining order today for the Meeker Oak. Well, that is a minimalistic type of notice. It fails to identify the time and place of the making of application, which is the statutory requirement of RCW 7.40.050. It fails to provide a motion. It fails to provide the basis for a TRO. It failed to serve a complaint. It failed to identify what court the TRO was being sought in. So there was not adequate notice and a meaningful opportunity for the city to respond. And the failure to provide a notice and a meaningful opportunity to respond, as was held in the Henry Estate of Smaldino case, effectively denies due process and renders a TRO issued in that manner void. The TRO also is drafted in such a way that there are absolutely no findings whatsoever. There is no finding of harm. There is no finding of what injury the plaintiffs would suffer. There is no finding as to why any such harm would be irreparable. There are no findings as to why notice could not be given to the city and why it had to be dispensed with. There are no factual findings at all. There is no end date. There is no provision for conversion of the temporary restraining order into a preliminary injunction and consideration of a proper motion for a preliminary injunction. All of that violates CR 65. There was not even a motion upon which a TRO could properly be issued. There were no findings regarding the public interest and the threat to public safety that is posed by the unfortunately dying Davis Meeker Gary Oak. That threat to public safety, we believe, is a paramount consideration and is motivating why the city of Tumwater is seeking to make its roadway safe, as it has a duty to do for which it can be held liable.
Mr. Myers, should this TRO be dissolved, I have a question for you regarding what will occur after that. Has the city made plans to proceed with removal of the tree if the motion is dissolved? And if so, on what date?
The city has a contractor who was on standby for Tuesday afternoon. That was deferred until— I
understand. I'm asking you, if I dissolve this TRO today, what will happen? What is the city's intention, and is there a date set?
The city's intention is to notify the contractor to remobilize and to remove the tree in as soon a fashion as time allows. My suspicion is that that would be a matter of a couple of days.
So possibly Monday morning?
Possibly.
All right, thank you.
And then finally, as I mentioned, the duty to provide a safe street and a known hazard that has had limbs fall into the street creates a situation where the city has clear liability if it does not act. And by preventing the city from acting, the city would incur substantial liability if someone is injured. And there was no security whatsoever provided for that. There was no security whatsoever provided for additional costs of the tree removal. And there was no security provided for the closure of the road, which may have to result if, in fact, we are prevented from removing this known hazard in the street. I want to also call the court's attention to the provisions of CR 65 and what are the consequences where these deficiencies exist and where there is no provision for conversion to a preliminary injunction, as was provided in this case. Under CR 65B, if a TRO is granted without notice, the motion for preliminary injunction shall be set down for hearing at the earliest possible time. When the motion comes on for hearing, the party who obtained the TRO shall proceed with the application for a preliminary injunction. And this is important, if the party does not do so, the court shall dissolve the temporary restraining order. The plaintiff in this case has made no provisions for a TRO to be converted to a preliminary injunction. The order that they drafted and presented to the court ex parte makes no end date and no provision for converting it to a motion for preliminary injunction. Indeed, by not even filing a motion, the court was prevented from considering the applicable law for a TRO, including possibility of success on the merits, possibility of irreparable harm, and weighing the need to issue a temporary restraining order. The court was also prevented from considering the security that was necessary. And in considering the security, I think the court needs to consider what type of damages might exist if that tree fell into the street and hit a passerby. What are the possible damages if it killed a child? What are the possible damages if it maimed a mother? That's the duty that the city is required to prevent and keep its streets in a safe condition for the traveling public.
You have 2 minutes remaining. Would you like to reserve time for reply?
I would just like to suggest in closing, I'll reserve a minute for reply. The amount of damages should also consider the cost of removal and the cost of road closure. I'm thinking that that would cost $10,000 a day in order to close Old 99. And this court should, if it decides that a TRO should remain in place, it should absolutely require a minimum of $140,000 for those costs and $10 million to protect the city against the liability that it cannot prevent because of the injunction.
Thank you.
Can I speak from the podium?
You may.
Thank you, Your Honor. At the outset, plaintiff would request that Your Honor construe plaintiff's motion as one to impose temporary injunction as opposed to one to extend the TRO. The mayor says that she should be able to cut down this tree and kill the baby birds in it. Aside from the legality, the fact that she is willing to kill baby birds
I'm going to ask you to slow down, please, so that our court reporter can keep up with you.
Sure. Aside from legality, the fact that she is willing to kill baby birds is alarming on a personal level. And it is no different from her stance as to the tribes. She is seeking to cut down a tree cherished by tribes against their wishes and without giving them an opportunity for input.
Ms. Larson-Kramer, I don't have any tribes appearing in this case. How does your client have standing to raise issues pertaining to the tribes?
The tribes have expressed their wishes through the declarations, the tribal elder declarations that we have submitted suffice to show the standing as far as our group. We are not speaking for the tribes. Yes, you're absolutely right. I want to make that clear. And nobody's intending to say we're speaking for the tribes.
And the tribes are not a party to this matter.
You're right. The tribes are not a party, but
Okay,
the fact remains. The declarations show that she has failed to do her duty to provide notice to the tribes. So, there's no ambiguity there. So she has not provided them opportunity for input. That is the main point. This court should put her plans on hold to give the baby birds time, to give the tribes time, and to give the council time to exercise its authority and pass a city ordinance that is harder for her to misconstrue. Under the Archaeological Resource Law, RCW 20...
And again, I'm going to ask that you slow down.
Thank you.
We have a natural tendency to speed up, particularly when we're reading.
Yes. Under the Archaeological Resource Law, RCW 27.53.060, the mayor cannot cut this tree down without an archaeological excavation and removal permit. The mayor has not applied for the permit. She also cannot cut down the tree without a permit. Under Tumwater Municipal Code Section 2.62.060, the only exception is to do emergency repairs. Removal of the tree is not a repair. Because the baby birds are in the tree, the Federal Migratory Bird Treaty Act does not allow removal of the tree at this time. Additionally, the mayor's actions have been arbitrary and capricious. Anyone who drives down Henderson Boulevard at Watershed Park after a windstorm knows how many large and dangerous branches fall onto the roadway there. But the city of Olympia doesn't come in and remove all the trees. You don't jump to remove as your first option, even with a regular street tree. And with a culturally significant tree, you should be bending over backwards to use mitigation techniques that are less drastic than removal. But the mayor didn't do any of that here. I want to touch on the mayor's argument that plaintiffs should post a bond because there is an imminent threat. The mayor contends someone is going to get killed and the city is going to go bankrupt because the insurer won't insure this tree. I want to point out the mayor's timeline here. Her arborist's death warrant report was in October. For the next 7 months, the mayor let this tree live. It has now been a year since the branch fell originally. If the mayor was truly worried about imminent threats, she would have gotten someone in there to do emergency pruning. There is no imminent threat. There is no loss of insurance coverage. This is a smokescreen. I would also like to point out that removing a tree of this magnitude is extremely costly. Pruning is a fraction of the price. If the mayor were truly worried about money, she would have pruned it by now. There are so many things wrong with the mayor's plan that it boggles the mind how the city council could let things get this bad. The council is the body that makes the laws. The mayor carries them out. She works for them, not the other way around. And yet they stand by and take no action. Voters should take notice. The plaintiff asks the court to issue a temporary injunction to at least July 30th. Thank you.
Thank you. Mr. Myers, you have 1 minute remaining.
Yes, Your Honor. I'd like to address a couple of things. One, there is no pleading that raises archaeological resource laws for the state of Washington. It's not before the court. City's ordinance does not apply because a tree is not a structure, and the definition of structure applies to man-made constructs, not trees. The Migratory Bird Treaty Act, we cited to you in our reply brief, case law under the federal cases, including ones that are cited in the complaint by the plaintiffs, that shows that it is not a violation of the Migratory Bird Act to cut down a tree, even where there is a nesting migratory bird. It is not the Endangered Species Act. It's not applied to a habitat take. It applies to hunters going out and shooting migratory birds or intentionally killing them. That is not the case here at all. And then it's difficult to address the blatant political appeal that is being made here. I'd like the court to address the law. And we've shown you that the law does not allow a TRO in these circumstances.
Thank you. The court is prepared to rule at this time. This court's ruling must be based solely on the law and cannot consider the political arguments regarding the wisdom of removing or saving the tree. Under the law, a party requesting a temporary restraining order must show three things: a clear, legal, or equitable right, a well-grounded fear of immediate invasion of that right, and that the act complained of will result in actual and substantial injury to the moving party. All of these requirements have to be met, and the plaintiffs have not met the first criteria. To establish a clear, legal, or equitable right, the moving party must show that it is likely to prevail on the merits. Here, plaintiffs make a number of claims, and I'll begin with the claim that the legal right arises from the Tumwater Municipal Code. The mayor's decision to proceed is compliant with the code. There was not an obligation to obtain a permit before removing a historic tree as opposed to a historic structure, and the code allows removal of a tree the city determines is posing a hazard. With respect to the newly raised argument regarding RCW 27.53.060, the defendant is correct. That was not briefed previously. A quick look at that statute reveals that that chapter of the law addresses archaeological resources, not trees, and therefore that is not applicable, and it does not provide this court a basis for a finding of clear legal or equitable right. There are allegations of a federal law possibly pertaining to endangered species or migratory birds. This was not clearly established in the briefing. The plaintiffs have not shown a clear legal or equitable right under federal law. They do not have standing to raise arguments on behalf of the tribes regarding notice. That is something that the tribes themselves can, of course, raise. They have not joined in this action. Therefore, the temporary restraining order will be dissolved. However, when asked, the city's attorney stated that the tree may be removed as early as Monday morning. If that were to occur, that would destroy the plaintiff's ability to appeal this decision to the next court. I am going to provide sufficient time to allow the plaintiffs to make an emergency motion on appeal to the Court of Appeals. Therefore, this temporary restraining order will expire on Wednesday at 5 p.m. Are there any questions?
No, Your Honor, thank you.
I will prepare an order that conforms with the legal decision that I have entered. That will be entered today.
Thank you, Your Honor.
All right, and that ends this matter for today. Thank you.